All right, this is 241136, the state of Michigan versus Christopher Moore.
Good morning, Your Honor. Jessica David for the people, P86743.
Well, Your Honor, Jeffrey Fanta on behalf of Mr. Moore, who is present by Zoom. Judge, this is time and date set by the court for an in-person hearing relative to Mr. Moore and for a proposed bond violation. Addressing the in-person issue, Judge, Mr. Moore played me a phone message that came from the court that should have been, I think the court just called the wrong number and left a message on his number indicating a hearing, but it was directed towards Ms. Butcher. And so he did not have knowledge that he was supposed to be here in person. Number two, I would ask the court, after talking to Mr. Moore, request the court, based upon the landlord-tenant matter that was before the court, I think last week or the week before, would request the court recuse itself and set this matter for a hearing before Judge Slavin tomorrow morning. We would be prepared to address the violations at that time. And Mr. Moore will be here in person.
Okay, well, I want to address that. We can set this for the morning. I don't believe that that's grounds for recusal on this case. Mr. Moore was present. There was a landlord-tenant case. His conduct at that landlord-tenant case occurred in my presence in open court on Zoom and on YouTube. And I don't know that anytime someone in a case behaves poorly in a courtroom that I should have to recuse myself. I don't know that that's the appropriate remedy. I certainly believe I can be fair and impartial on this case. I certainly have concerns with the allegations of the bond violations, but at this point, at this point in time, I'm not recusing myself from this case. I don't think it's necessary.
Before a single word is spoken in this courtroom, understand this: you are not watching a simple missed court date. You're watching the slow-motion unraveling of a man who thought he could outmaneuver the system by hiding behind Zoom screens, silence, and legal technicalities. This case starts calmly, almost boringly procedural, but don't let that fool you. What unfolds next is a masterclass in escalation, missed appearances, recusal attempts, strategic silence, and ultimately a complete disappearance that forces the court's hand. And here's the terrifying part: every warning sign was already there. The judge saw it. The prosecutors saw it. Even the defense knew what was coming. The only person pretending not to understand the gravity of the situation was the defendant himself. So as you watch this unfold, ask yourself, at what exact moment?
For tomorrow morning, I'm going to be here. Mr. Moore will be here.
Okay. It should be in person.
He will be in person.
Okay. Miss Maudlin, I don't know what our day looks like. What's that?
Landlord-tenant.
I have landlord-tenant. It ends around 10. My second batch is at 10:30.
I'm here all day, Judge, so whatever.
So Miss Maudlin, maybe we'll just do it around 11:30.
I think there was another case.
All right, let's just make sure that there's something. I don't know what all we have tomorrow. 11 a.m. tomorrow. Well, Miss David was courteous enough to join us today from the prosecutor's office. This is not her docket. I'm guessing she's got another place to be tomorrow.
I do have court in the morning, Your Honor, tomorrow, but I can make like 11:30 work. I just circuit court sometimes is backed up.
I get it. Is that okay?
That's fine, Judge.
All right, Miss Davidova, you're free to appear via Zoom. Miss Butcher, you're to appear via Zoom. Mr. Moore, you're to appear in person.
Your Honor, before we go,
Go ahead.
before we go for the day, can the court inquire where Mr. Moore is presently?
My understanding is Mr. Moore checked in and told one of the clerks that he was out of state right now.
Mr. Moore is not commenting, Judge. He has a right to not say anything.
He's exercising his right to remain silent, Miss Davidova.
All right. Thank you, Your Honor.
And Mr. Moore, just acknowledge that the hearing's at 11:30. I would like you here at 11 so we can talk, okay?
Mr. Moore, you're muted. Okay, I see a thumbs up, so it sounds like he understands.
Yeah, I had asked him to mute himself and not say anything, Judge, so that's a good, perfect response.
Okay, so Mr. Moore, we'll see you.
This is one of the oldest courtroom moves in the book: blame confusion, blame communication, blame technology. And to be fair, judges hear legitimate scheduling mistakes all the time. But here's the problem: this defendant is already under bond conditions. That means the margin for error is razor thin. Once you're released on bond, you don't get the benefit of casual misunderstandings anymore. The court expects vigilance, not passivity. And notice something subtle here: defense counsel doesn't actually deny knowledge of court involvement, only the method of notice. That distinction matters. Because courts don't require perfect communication, they require reasonable awareness. And in this case, the court is already dealing with alleged violations. So this explanation doesn't clear anything up. It just delays the inevitable question: why is this defendant
People versus Christopher Moore.
Good morning, Your Honor. Jessica Davidoff for the people, P86743.
Morning, Your Honor. Jeffrey Fant on behalf of Mr. Moore. Judge, Mr. Moore has not appeared. I did try to call him. My call went straight to voicemail. I did check with security downstairs. He has not come into the building to their knowledge. I do not have an explanation for his non-appearance.
All right, and I would just note for the record, Mr. Moore was here yesterday and we set this for today so he could appear in person. He was advised at the time and the date on the record. He indicated he would be present. He's failed to appear. An immediate bench warrant will issue for his arrest. So if he's a flight risk, he's certainly, at least appears to be based on the allegations, a danger to Miss Butcher. So he will have an immediate bench warrant for his arrest.
Thank you.
Okay.
Thank you. And Your Honor, for the record, may I note Ms. Butcher is present today on Zoom.
Thank you. I recognize that and I noted it on the file. So, okay, we are all set. And Ms. Butcher, I'm sure that Ms. Davidoff is advised you on what to do in the event there's any contact. And
A recusal request is not a casual ask, it's an accusation wrapped in legal politeness. What defense counsel is really saying here is, something happened before, and we don't like how this judge saw it. But courts don't operate on comfort. Judges don't get removed because a defendant embarrassed himself or behaved badly in a previous case. If that were the standard, the justice system would collapse under tantrums. And the judge's response here is crucial: misconduct happened in open court, on record, and publicly. That doesn't create bias, it creates documentation. Recusal is about impartiality, not convenience. And when the judge refuses to step aside, that's not stubbornness, that's judicial duty. The court is signaling something important here: you don't get to reset the game just because.
We probably have to call and get him yet another attorney.
can you handle the arraignment today?
Yeah, I can handle I'll do the arraignment, yes.
All right. I mean, he
Yeah.
needs to be arraigned, and so, and then we'll let them know that we need yet another attorney.
Yes.
Uh,
I tried to explain to the client that I would schedule it with him so that we could talk at length, and that really upset him. I did
Okay.
explain that, I needed to go to the courtroom at this point and then speak with him on Zoom at a later date, but he wants another lawyer.
Okay, so let me call these the new one first. This is 241976 People versus Christopher Moore. So Mr. Moore, initially you had an attorney that was appointed through NDS, and they had the attorney they appointed was not I don't want to say qualified, but she didn't meet the standards under the Michigan Indigent Defense Commission's to handle a case of this nature. So she was removed from the case because she can't be on that list. Then Miss Watt was nice enough, kind enough today. She was called to stand in on this or come into the case forthwith so that you could have your court date. So I just want you to know what happened today. So now we have, Ms. Watt here. It was scheduled at 1:15. All we're handling today is the arraignment. So you're being arraigned on your new case. And I've known Ms. Watt for many years. She is a very good defense attorney. And obviously those are decisions you can make, at least for the moment. But I am going to proceed with the arraignment. And then if you want different counsel, Ms. Watt, it sounds like there's a breakdown.
Yes.
Okay. So, Mr. Moore, on this case, Ms. Watt, can I get your appearance for purposes of arraignment?
Yes.
If she's gonna be,
Cora Watt, appearing on behalf of Christopher Moore, P41508.
Okay, so Mr. Moore, we can get you a new attorney if you want a new attorney, but I'm arraigning you on these charges.
Your
okay,
Honor,
well,
we stand mute to make the formal reading of the warrant on the charges, Your Honor.
Okay, so Mr. Moore, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearing. If you can't afford an attorney, one will be appointed to represent you, as Ms. Choate was, now Ms. Watt was. And it's my understanding now that, Mr. Moore, you want to fire Ms. Watt?
correction. I have witnesses in here. She was not listening to what I was finishing trying to say. I had to stop because somebody else, as you can see, there's other court proceedings going on here with several other judges, several other inmates. Got a basketball gym that we're holding court next to. I have cancer. I just had a seizure while I was in custody at Taylor PD when I was.
This moment might feel boring, but it's actually one of the most important parts of the entire case. Why? Because everything is now locked into the record. Time, date, location, expectations, all clearly stated. And most importantly, the defendant acknowledges it. That acknowledgement kills future excuses. Courts live and die by the record, not by later explanations. From this point forward, any failure to appear isn't confusion, it's defiance. And watch how calm everyone is. No yelling, no threats, no drama. That calm is dangerous for someone who plans not to comply, because it removes any ambiguity.
2 or 3 hours ago. So of course she doesn't have discovery. She was just appointed, and that's not her fault at all.
It's clearly not my fault, ma'am. I was asked a question and I was trying to
telling
respond.
you. All right, Mr. Moore.
All I was simply asking, just let me know when I can speak, please. So we're not.
All right, well, you have 2 dates within the next 21 days. The first is your probable cause conference, which is set for September 4th of 2024. Following that, you will have a preliminary exam. You are to appear in person at that hearing, and that is September 9th of 2024. And we will get this back down and have another attorney appointed to represent you. Mr. Moore, are you telling me that there's been a breakdown between you and Ms. Watt that you believe affects her ability to represent you?
I didn't
Yes
say
or no?
anything. She said that she was going to go back into the courtroom. This is what she said. I didn't even say anything. She said she's going back in the courtroom. Oh, this ain't going to work. I was like, what's not going to work?
I don't speak like that, first of all, Your Honor.
All right. Well, let me ask you, Ms. Watt, instead of Mr. Moore, Ms. Watt, has there been a material breakdown where you can't represent him?
Yes, Your Honor.
All right. So you're being removed from the case.
Thank you, Your Honor.
But I'm setting bond on this case. Now, he currently has a $250,000 cash surety bond on his other home invasion case. This one is certainly even more concerning. So, because now he's gone to home invasion first.
Invoking the right to remain silent is legally sound, but context is everything. Silence in a vacuum is neutral. Silence when the court asks where you are, while discussing in-person bond violations, is not. That's when silence becomes loud. Defense counsel frames this as a constitutional safeguard, but the court isn't asking about guilt, it's asking about presence. And that distinction matters. Courts don't need explanations for silence, but they absolutely notice patterns. A defendant who avoids speaking, avoids appearing, and avoids confirming location is not exercising rights